Hi, this is Tim Santoni and welcome to the show. Today we're going to talk about Ban the Box. AB 1008, which was passed in California, and it impacts employers and their ability to do background checks and how they do background checks. Stay tuned. This is Tim Santoni and welcome to the show. Today we're talking about background checks, specifically Ban the Box, a law passed here in California that impacts the ability for employers to ask applicants about prior criminal information, how the background checks are conducted, and the assessment that must be done if and when convictions are found. This is a little series that I like to call Employment Background Checks Demystified, where we try to answer those questions that our clients are always asking us and reveal some of the myths behind background screening industry as a whole. So keep in mind, if you're an employer in California, consult with an HR consultant or an employment lawyer before you adopt any of these procedures. But first off, here's some best practices. Before you conduct a background check, you want to make sure you have a conditional offer of employment in place that's contingent upon completion of the background check, using a compliant authorization form for the background check that the applicant will authorize and disclose, and it's as a standalone document from any other documents in your hiring practice. And you must clearly communicate to the applicant who's doing the background check. So now that you've got all that out of the way, let's move into the background check. Okay, so now you've got a conditional offer of employment in place, you've got an authorization to conduct that background check, now you're entering that background check. You wanna make sure you're using compliant forms and you're working with the CRA, or Consumer Reporting Agency, a background screening company that understands adjudication rules for employers in California. One critical thing to keep in mind is that 7 years convictions only is the rule of thumb when it comes to reportable records for most California private employers. Again, check with your HR consultant or your employment attorney, but this is a basic standard. Now, with the new legislation, you cannot ask about prior criminal convictions until that conditional offer of employment is in place. But one thing to keep in mind is it may be wise to ask the applicant about prior criminal convictions or history once the conditional offer of employment is in place. You can now ask about this and then conduct your background check. If the background check comes back and you're aware of these convictions, you can report them, or if they fail to report them on that form, now they're lying about their background history and you can use this because they're lying on a company document. So one very big change that Ban the Box legislation incorporates is a three-part assessment that must be conducted on all background screens conducted where criminal convictions are reported. These three-point assessment must be conducted independently, documented, and be part of the pre-adverse and adverse action process. The first one is the nature and gravity of the offense. This means that you must clearly understand from your background screening company what conviction specifically is being listed on the background report and what specific charges they've been convicted of, so you can make this assessment. This means if it's assault, battery, murder, or simply a moving violation in a vehicle, you must clearly understand that. So we encourage you to reach out to your CRA or background screening company and get clear guidance on what those convictions are for, so you can make this assessment. The second piece of the assessment is the time that has elapsed since this conviction. This means that on that background screening report, you must have a date of disposition and you must look at that and count back the time since that's happened and assess that. So if it's been 7 years or just almost 7 years or 6.5 years, this would be different than if it happened a year ago, right? Because there's an inherent ability for rehabilitation and other things that could have happened, and this must be considered. So the second assessment is the time since the offense has occurred. So you must make sure that your background check has that information on it, and if you don't, ask your background screening provider for clearer details so you can make this assessment. The third and final piece of the assessment is the nature of the job. This means that as an employer, you must take a look at the conviction. You're assessing the nature and gravity, the time of the offense, and now you must assess how this conviction impacts the employee's ability to do this job that they're being assigned to do. A good example would be as if they've had 5 moving violations and a DUI and they're going to become a driver for you. This would be a direct impact situation. If they've got 2 assault and batteries and they're beginning going into the home of your clients, this could be an issue. But if they have a minor weapons possession misdemeanor that happened 7 years ago and they're going to be working in the warehouse, you have to make a decision on if this impacts your business and it affects the nature of the job. So making sure that you have this 3-point assessment completed is super important. If you then elect to take a pre-adverse and adverse action process, you want to make sure that the applicant has the ability to contest any charges that are reported that may not apply to them. And now if you're going to take that adverse action, you must also make them aware of the assessment that was done and give them the right to file a claim with the DFEH, or the Department of Fair Employment and Housing. This encapsulates the whole thing. So in summary, you cannot ask any information about criminal history on your applications. You cannot ask any information about criminal history until a conditional offer of employment is in place. You must conduct your 3-point assessment, and if you still look to take pre-adverse or adverse action and not offer the employment based on the findings of the background check, you must give them the right to file a claim with the DFEH. Thank you so much for tuning into the show. If you have any questions about this complicated new law affecting California employers, please leave them down below, and we'll look forward to connecting with you in the comments. Thanks.